Welcome to another episode of Divorce Explained with myself, Leanne Townsend, and my colleague, Steve Benmor. This week, we have a new topic that we haven't covered, but it's a very important one. It's why your family court pleadings matter. And I know some of you may be saying, like, what is a pleading? I don't even know what that is, let alone why it matters. And if that's the case, you're in the right spot because we're going to tell you all about pleadings and why they are so important.
So it's interesting because one of the things that I often rail against litigation about is pleadings. Why? Because when people hire a lawyer to begin settling their case, they try to negotiate without going to court. And then if things just don't work out through negotiation or mediation, we therefore have to start a court case. And the word start a court case is the simple language for pleadings. In other words, the word pleading comes from the word to plead or to ask. So in Ontario, a pleading in family law is called an application where you list what you want and why you want it. And you also have to list under which law you want it. So if you do a good job, you will first determine what it is that you want. Your lawyer and you will discuss whether you could even get it. So for example, an unmarried couple cannot get a divorce, or a married couple will not be treated the same as a common law couple. So it's very important that the pleadings reflect what is a realistic request and whether the law allows that to occur. And then you list the reasons for it. And if you mess up on any of those, there is this thing called an amendment of pleadings, which tends to be expensive because you started the case with one set of asks. And then later on, you realize, oh, no, I forgot to ask for something. I got to amend my pleadings. And sometimes judges don't allow it, or sometimes they will allow it, and they will allow it at an expense to you. And you have to pay the other side's costs because now they have to amend their defense to what you asked for. So pleadings are really important for the initial stage of starting a court case. And so often, however, people are a little blurry at the beginning, and then they realize later on, oh, I should have asked for this and not that. Have you had, Leanne, any experience with either problematic pleadings or amendment of pleadings?
Yes, I've had experience with both. So, in terms of problematic pleadings, I've been in situations where a client retained me, but I wasn't the first lawyer on the matter. So it was another lawyer who drafted the pleadings. And, I've found sometimes they can be a mess, or they're not making all of the claims that I think the client should have made. And that type of situation comes up a lot because I think that as lawyers, we have our own personal style of how we like a pleading to read and be organized. And it is a bit of an art, I think, drafting a good pleading. And so not everyone is equally good at it. And so when, as you say, when you inherit a case that perhaps another lawyer drafted the pleadings on, that can sometimes be problematic and you may want to amend them. And then the other thing that happens is, even with my own pleadings, a client retains me and their matter could go on for a very long time. It might be 2, 3, 4 years later by the time we're getting to the point where maybe it's going to go to trial. And in that period of time, their own situation may have changed because it's been such a long period of time. And so it becomes necessary to amend it, not because the original pleading wasn't drafted very well, but just because things have changed. And, in that type of situation, both parties may need to amend their pleading. So you might be able to avoid the cost issue a little bit, but it's one of the things about that that's really important too is that as lawyers we always need to go back and look at the original pleading, because if you're going to trial and things have changed and you didn't look recently at the original application, you may be thinking that you're going to be making certain claims, and you go back and look in the pleading and that claim isn't even there, and you're planning on calling evidence about it at trial and making that claim. And so then it's really important that you get that pleading amended. And so reviewing the pleadings throughout the process is really important.
Absolutely. And when we use the phraseology, why do pleadings matter? I want to give a couple real life examples. So, husband hires lawyer to resolve his divorce with his wife. They fill out the application. It's the pleading. Says he wants a division of property. He wants parenting to be addressed, possibly child support and spousal support. Checks off all the boxes. And then 6 months, a year, 18 months into the case, they discover, when they bought their matrimonial home, they placed the wife on title, not him and her, and not him. And so in order for him to participate in the rise in the value of that home from the date of separation to some future date, that will require an amendment of pleadings. Now, had the husband and the lawyers known at the very outset that the house was not in his name and the wife's name, but only in the wife's name, then they would have pleaded then that the wife is holding the matrimonial home in trust for both of them. And that therefore he is asking the court to rule that he be treated the same as a joint and equal owner of the home. This is an example of when we would amend pleading. In some cases, just like you said, Leanne, where the circumstances are changing over the course of the period from the time you started the application to the later date. Well, in family law, the issue of parenting is a forever changing event. And so what happens if between the date of separation and the date of trial or some future date, the request is now no longer for joint custody and joint decision making. Maybe now the request is for sole custody and sole decision making. Of course, these days we don't use the word custody, we use the word parenting, but my point is the same. Maybe there's been a year and a half or 2 years of estrangement or alienation. Maybe you need now something that you didn't know you needed before, like a parenting assessment. So there may be the need to seek an amendment of pleadings to ask for the very things that you either should have asked for or didn't even know to ask for until some later stage.
And another issue that comes up with pleadings, and I'm interested to get your experience and strategy with this, is sometimes a client retains you, and the hope is that the matter ultimately, is going to be settled. But for whatever reason, you need to commence an application and make a pleading, draft a pleading. And because when you're doing the pleading, you want to put everything in that to make sure that you're making all of the claims that are open to your client that they want to make, and you're putting their best case forward in a sense. Pleading sometimes can be very inflammatory because especially there's a parenting issue and the other parent has done some things that put them in an unfavorable light potentially as a parent, and you have to set some of these things out in the pleading because it goes to the issue of parenting. But then the other parent, when they're served with that pleading and they read it, they get outraged that how dare them be saying this about me, and they get all angry. So then they want to respond in their answer, of course, with similar types of things, and then things can get really hot, and they can get more conflict ridden in that initial stage after the pleadings have been served and filed. Whereas before that point, things may have been a little bit, less conflict ridden. And so it can be a bit of a balancing act sometimes in terms of saying the things you need to say to cover off your client's position, but with the goal of not unnecessarily inflaming the relationship between them. And I'm wondering how, Steve, what's your experience and how do you deal with that?
It's such an important point. If we had to choose of all of the different lessons or takeaways from today's workshop, it would be the one that you just covered. Why? Because unlike any other kind of litigation, when it comes to family court litigation, the relationships generally continue well past the departure of the lawyers and the judges and the mediators and the assessors. And yet the work that we professionals do may very well determine what that relationship is in the future. And so there are different schools of thought on your question. One is put everything in, destroy the character of the other person in order to seek the utmost of positive relief for your client. And given the fact that a family court application is the ending of a relationship, and the storyline of why the relationship ended may very well involve some acts that are blameworthy. And so why not list every last bad behavior in the application in order to cause the judge who reads it one day to think, oh, poor applicant, and the respondent, what a jerk. So the applicant writes all of that. The respondent, of course, is up in arms, and they counter. And that is the first step in the litigation, and it's the worst first step, because what could have been a mini fire put out very quickly by two very reasonable lawyers now becomes an outright war. And not only that, they line up their witnesses. The applicant will have his or her witnesses to support all of her allegations. The respondent will have his or hers. So that's scenario one. Scenario two is put in very little. Just say, this is what I want. This is why it's in the children's best interest. This is why I need spousal support. And we have property. We need to take an inventory of it and divide it. Scenario two rarely occurs, sadly. And part of the reason for why it doesn't occur is because what happens when that person does that and then the respondent responds in a very mean-spirited way by laying out all of the allegations. Well, the reason he is seeking a divorce is because he committed adultery and would love nothing more than to have the children with him half the time and to have our house sold and the property divided. But let me tell you, there's a story here, the respondent might say in her or his pleadings. So one reason why scenario two doesn't often occur is because the applicant might want to preempt what the respondent will say when he or she says something in response. And then it becomes a tit for tat, which is really bad. So what's my solution? My solution is probably undermining the question of the workshop today, which is don't do pleadings, because pleadings are the first step towards a very destructive future series of events called family court litigation, which includes a tremendous amount of hostility, a tremendous amount of adversarial behavior, high legal costs, a delayed period till resolution, and usually some pretty nasty feelings on the departure side. So could pleadings be sanitized? They could. Does it require 4 people to all agree that they be very clean, very polite, very diplomatic pleadings? Yes. But the very qualities that would have gone into that level of cooperation probably wouldn't have caused them to go to court, because they probably would have been able to be that cooperative through negotiation or mediation.
No, that's very true. And as a lawyer, I find it interesting with different clients that I work with in terms of their level of involvement in the pleadings. There's some clients who they almost want to write it, and I, as a lawyer, to me it's my name is on that document, so I want to make sure that it's containing things I think should be there and not things that I don't think should be there. And some clients are, more hands off about it. They understand that the lawyer is the one who knows the law, and they're okay with the lawyer editing and cutting stuff out that maybe they thought should be in there. But there are other clients who you really have to push back as their lawyer not to include certain things and explain to them the reasons for it. But some clients they need that. It's almost like they're looking for a vindication almost in their pleading. They want everything possible in there. And then on the flip side of it, the reaction with some clients, with a lot of clients, when they do receive the pleading from the other side, is, one of upset and outrage. And I always have to remind the client that just because it's written in the document, in the pleading, and the other side's pleading, it doesn't make it true. It doesn't mean that at the end of the day, a judge is going to believe it. It's just claims, and it's just the other side putting forward their version of events and their version of the case, but it doesn't make it true, and it doesn't mean anyone's going to believe it. And I really have to remind clients of that.
But it's hard. It's hard because, first of all, before we even get into pleadings, there's already hurt feelings. And so those hurt feelings already exist, but they exist in the heart and in the mind. Then when somebody sees it in writing, oh boy. And then we have to tell them, by the way, this thing called a pleading, it's public record. The world can read it. Or more importantly, your children one day will be able to read it because it's public record. And in the era of digitization, right now, for you to be able to read that pleading, you just have to pop over to the courthouse near you and pull the file. But in the future, it may very well be that all these files are available to the public via digital access, in which case, when mom and dad are fighting and putting allegations to one another in pleadings, those little children one day might be able to go and read all about that when they're adults. And it may not be a nice experience for them. And so pleadings have this element of publicity. And although nobody cares about the average Joe on the street, media outlets do go to courthouses to get the pleadings on high-profile cases. And in some cases, not only do the pleadings disclose information like, Angelina Jolie and Brad Pitt, but it would disclose some private information too, like sexual behaviors, infidelity, theft, possibly criminal behavior. And then on the financial side of family law, it would include people's income and assets and debts and who they owe money to. And so when we're dealing with high profile people, or not even high profile, just people that are important, pleadings are public and it discloses everything. Yes, people could apply for a sealing of an order, but judges not always grant sealing of an order so that the media has access to it, because the notion, once you go to court, is that it's a public system, it's an open system. And one of the ways to ensure the integrity of the system is to ensure that it is open. Well, that openness, that transparency, is the very thing that violates a person's privacy. So anyway, the topic today is why pleadings matter. The fact of the matter is they do. They matter a lot. It affects every part of the case. It affects it from what you get from the beginning to what you get at the end. It affects the feelings that it creates, including the bad feelings. And it also is the very act of taking your case to court, which I think Leanne would agree with me on. If we can solve a family's problems without going to court, we've done a very good job for that family.
Absolutely.
So with that said, thank you for joining us for this episode of Divorce Explained. Thank you, Leanne, and we will catch you all next time.
Bye for now.